This is Rahul Magan here as a Group Chief Executive Officer, Treasury Consulting, and also pursuing LLB, law degree. As we speak, Treasury Consulting is a multi-asset and multinational hedge fund. By multi-asset, I mean to say we actively cover our positions in multiple asset classes of the globe, which includes gold, silver, platinum, palladium, oil-related spreads, natural gas, base metals, agriculture commodities, contract for differences, exchange traded derivatives, equities, and foreign exchange. Probably very soon, our hedge fund desk would be adding more asset classes like daily leverage certificate, also known as DLC, and factor certificates from Switzerland. Please be note that by multinational, we mean we actively cover our position in variety of continents and countries, which includes United States, European Union, and Asia Pacific region. Please note this carefully that we are a proprietary hedge fund. By proprietary, I mean to say no third party. Let me repeat, no third party can invest capital in our fund. Please take a note of that. I started my LLB, law degree, and if God is kind, I would be heading for LLM also, which is a master's degree in law. And I'm assuring you that in my legal career, I would be doing what I did in the financial markets, because I would be going in deep and I would be talking all those sensitive issues, all those issues which are subject to interpretation, specifically talking in terms of criminology, in terms of arbitration, and in terms of corporate disputes. My specialization would be criminology and arbitration. Eventually, I would be adding corporate disputes in my kitty. Our legal desk has already started. On time-to-time basis, we are uploading videos in our legal desk, like judicial management, like the respective laws by honorable courts in India. Very soon, we would be starting uploading about respective laws covering honorable courts in Singapore and UK, which is called English law. Today, I would be talking about the guidelines, rather the jotted points, the important points laid down by Honorable Supreme Court of India as far as the Ex-Parte order of injunction is concerned. Let me repeat, Honorable Supreme Court laid down few guidelines, rather the jotted points in short, as far as the Ex-Parte order of injunction is concerned. But before we move towards the point laid down by Supreme Court, we need to understand that what is injunction. Injunction is nothing but a kind of stay. Sometimes this stay is for a while. Sometimes this stay is interlocutory, which means in between of the suit. Sometimes this stay is restraining, which means the court is asking either the plaintiff or the defendant not to do this. It depends who is raising question on whom. And sometimes this is, permanent, but not the permanent what I'm looking forward. Depends upon various circumstances. To be honest and precise, different countries of the globe have their respective benchmark as far as injunctions is concerned. Unfortunately speaking, injunction is now turning out to be a very interesting subject as far as the law is concerned. Because if I speak about injunction, then in arbitration and cross border disputes, injunctions are often used. Example, anti suit injunction, anti suit injunction, anti enforcement injunction, anti arbitration injunction, anti arbitration injunction. And God knows, like I said in my earlier videos, that law is as interesting as financial market. It completely depends on you how deeply you are studying this topic. So every second day, a new judgment is coming up in the public domain. Sometimes the judgment coming by Indian honorable courts, Singapore honorable courts, and different honorable courts. Now, these judgments, you just need to study them, you just need to link them, and you just need to understand the exact, circumstances under which the court has given this judgment. I understand that this is very tough. Tough in the sense like most of the people not bothered to do this much hard work and all. But like I said, in financial market, you have to go in detail. Similarly, in the law, you have to go in detail. In this video, I would be talking about ex parte injunction. Generally, the proceedings are bi-parte, which means the plaintiff who puts the case, the defendant who is defending the case, both are parallelly standing along with their counsels, and they represent their opinions towards the court. It could be a trial court, the first appellate court, second appellate court, session court, high court, or probably some tribunal, or maybe the Supreme Court of respective country. But having said that, many a times we have ex parte injunction also, ex parte litigations also. Ex parte is a very difficult word to digest. Rather, ex parte is a very difficult word to comprehend. Because the reason is different countries of the globe have their respective benchmarks as far as ex parte is concerned. Example, X country laid down these parameters. Y country laid down these parameters. India laid down these parameters. So when we speak about ex parte, we really need to understand that the parameters being raised by the respective courts in that country. Unfortunately, these parameters might differ as far as the civil procedures are concerned, as far as the criminal procedures are concerned. Because generally the disputes are of two types. For a while, please exclude arbitration apart from the discussion for a while. One is the civil dispute, land dispute, rent agreement, and variety of cases. One is the criminal dispute. So injunction in a civil dispute is a complete different thing, like injunction in a criminal dispute. That we need to understand very well. So this is a very interesting topic, and I'm telling you that in the last several years, like I'm reading more and more from the internet about the injunction, I'm finding that a lot of new literature is coming on the internet as far as the injunction is concerned. Next, we would be covering in our second. Ex parte injunction means one party got a kind of restraining, probably temporal, probably permanent or interlocutory order as against the second party from the court of law. Of course, like I said, different countries have their different guidelines as far as the issuance of ex parte is concerned. And today I would be deliberating about these guidelines by Honorable Supreme Court of India. According to the information in the public domain, the apex court means Supreme Court, the apex court in Morgan Stanley Mutual Fund versus Kartik Das laid down the factors which would weight with the court in grant ex parte injunction, and the said factors are as follows, which means Honorable Supreme Court laid down the following factors that courts needs to consider while granting the ex parte injunction. Number one is that whether irreparable or serious mischief will ensue to the plaintiff, which means the plaintiff who is putting the case, whether the damage is irreparable or it is completely serious in nature. This is what Honorable Supreme Court would like to say. Second, whether the refusal of ex parte injunction would involve greater injustice than grant of it would involve, which means assuming the courts would say no to ex parte, whether it is temporary, it is permanent, it is temporal, it is a restraining order, or it is interlocutory, IA. Whether the refusal would have more injustice than granting it. That's what Honorable Court would like to express. The court will also consider the time at which plaintiff first had notice of the act, complained, so that making of improper against a party in his absence is prevented. Which means the court where it is being litigated needs to see that at what point of time the plaintiff, which means the person who puts the case, at what point of time he noticed or he complained, so that the second party, which is definitely a defendant, it should not be improper order against a second party, because ex parte means the second party is absent. This is ex parte. Means second party not represented his or her opinion. Because his or her opinion is not being represented, henceforth the courts needs to see at what point of time the plaintiff is also known as plaint. The plaint came into the picture. Number 4, the court will consider whether plaintiff has acquiesced for some time, and in some such circumstances, it will not grant ex parte injunction. That's a very important point Supreme Court has said. And we need to consider that point. But you need to understand that this point, the court will consider whether the plaintiff has acquiesced for some time, and in such circumstances, it will not grant ex parte injunction. Number 5, the court would expect a party applying for ex parte injunction and in ex parte injunction to show utmost good faith in making the application, which means his hands should be clean, right? His hands should be completely clean. The facts which he is representing before the court of law, It should not be, it should not be fake. It should not be frivolous. It should be completely correct fact, which he is representing. Supreme Court and the Honorable Courts on time to time basis on the fact of stressed that the fact should be genuine, reasonable, and it should not be fake and frivolous. Honorable Court, including Supreme Court of India, on time to time basis raised concern about the abuse of the process, abuse of the various criminal laws in India, like 498A, IPC, Indian Penal Code, 406, Indian Penal Code, your 156.3, Indian Penal Code, 354, Indian Penal Code, and respective laws. Supreme Court also took some serious step, and we should be thank you to Supreme Court to make sure that the process of abuse should be stopped as early as possible. Henceforth, Supreme Court is right in saying that the court would expect a party applying for ex parte injunction to show utmost faith in making the application. Even if granted, for a while, assume, even if granted, the ex parte injunction would be for a limited period. Like I said, it could be temporal, it could be permanent, it could be interlocutory, right? It could be restraining. But here is a catch, and although I'm going in detail, I'm trying to study more and more about this judgment, but Supreme Court said even if granted, the ex parte injunction would be of limited period. Now, what is the definition of limited? This is what I am trying to understand from the internet. I'm trying to understand from the judgment, because that has to be defined. That limited, it could be 30 days, 60 days, probably 90 days, maybe 120 days, or Supreme Court is stressing on the interlocutory. This is, I would request the Honorable Court to kindly stress on this fact, which is limited period. The reason being, I am saying each case is different. Especially in the financial markets, especially in the cross-border disputes, especially in the arbitrations, each case is different. Although the title may be cross-border, title may be arbitration, but the sanity, the depth, and the understanding of each case is different. Henceforth, that limited period which Honorable Court is referring should be comprehensively defined, along with few catches, like this should be the catch and XYZ. But still, like I said, I'm reading in detail, and I would let you know in case I'm getting more information about that. The general principles, like prima facie case, prima facie means what you say, that once you look at something, you feel like this has done, this has committed, or this has not committed. This is prima facie. General principle like prima facie case, the balance of convenience and irreparable loss would also be considered by the court. Guys, I can't explain that, because balance of convenience and irreparable loss are very heavy words. And we need to refer CPC, which is Civil Procedure Code, and CRPC, Criminal Procedure Code, because the definitions of balance of convenience and irreparable loss is being defined there. But having said that, these definitions are subject to case basis. Like I said, each case is different. The gravity, the sanity of each case is different. But having said that, I completely in sync that the principles like prima facie, on prima facie basis, the balance of convenience and irreparable loss would also be considered by the court. It is abundantly clear that the Apex Court from time to time made orders so that interim orders are not made merely on asking. It means that it should not be like you went to court and you got it. Please remember that injunction is, if you are allowing an injunction, it means you are kind of setting up a landmark, right? Because tomorrow, today, if you are allowing injunction, it means that tomorrow anyone can come and say, this court gave injunction in this case. So it's a kind of landmark. And if the injunctions are provided by the higher courts, then it is automatically a landmark. And this is what Honorable Court is trying to say. If it is abundantly clear that Apex Court, Supreme Court, from time to time made orders so that interim orders are not made merely on asking. But although the decisions mentioned hereby are binding on all concerned throughout India, because of course, Supreme Court decision is binding across India, all courts. Please to take a note that these guidelines is we need to understand, we need to study, we need to see. It would be better if we study the judgment on time to time basis and different judgments came on time to time. Guys, please do remember that ex parte injunction, granted or not granted, is based on the facts which are provided by the plaintiff. Now, the facts which are provided by plaintiff is definitely is a part of petition, right? Because petition is what? Petition is nothing but a legal document which is being framed by either a law firm or a respective counsel, or probably the petitioner himself, sometimes in case of self-litigation, where he or she is trying to present each and everything about the case, start from the beginning till the end. And please do understand that unfortunately we have a tendency that the petition is nothing but a piece of paper, rather a bunch. And we have a tendency that no one study the petition. No, I completely disregard that. I always feel that petition is the first evidence you are having. Example, if you are a plaintiff and you are filing a petition of 40 pages, assuming, if you're filing a petition of 40 pages, it means you have mentioned the scope and size of the case, how it started, how it went ahead, what various U-turns happened, and so on and so forth. Common sense. In this, you have made various allegations against the defendant. Allegation X, Y, Z, P, Q, R. Sometimes the plaintiff give the evidence also. Sometimes they do not give the evidence also. People believe that they have signed the affidavit and there is no need for evidence, but unfortunately, the process of law is misused. And like I said, there are many criminal laws which we are having, and the honorable courts on time to time basis stressed the fact that it should not be misused. I strongly feel that petition is the first source of evidence, which strongly means that once you are getting a petition from the plaintiff, take it alternatively, the plaintiff is filing petition and the defendant is filing reply. Common sense. Please read this thoroughly. Don't take it lightly. Don't just take it as a bunch. Don't just take it like, guys, this is waste of time. This is a bunch. No one studied this. No. This is not the right attitude in the law. Take it very, very seriously and make sure that you will reach to the catches which is being left by either party. Example, you are a defendant and you got the petition copy. Now, once you got the petition copy, you see the catches which being left by the plaintiff. Try and understand whether plaintiff would be able to give the I would say the evidence on record to the before the honorable court or not, and that evidence has to be documentary. That evidence has to be genuine. It should not, I'm not talking about fake and frivolous, right, guys? Please do take a note of that. So, example, I just take an example. There is a cross-border dispute. One Indian bank sold a set of securities to a hedge fund in US, assuming. In this, the agreed price based on VWAP. VWAP means volume weighted average price. And assuming that VWAP came at 25 rupees, assuming. After a few months, the hedge fund sued that bank and saying the VWAP turning out to be 23, which means the bank overcharged that hedge fund. Just a hypothetical case. The bank can easily litigate that, provided they have knowledge. The reason being, there are various models of VWAP. At least 6 to 7 models of VWAP. And if the contract is not specifying in an affirmative way, affirmative means stressfully in writing. If the contract is not defining this in an affirmative way, that this methodology of VWAP, volume weighted average price, to be used, okay, as compared to the 7 top VWAP methodology, in that sense, you can easily appeal against the judgment or maybe the injunction which is given up by the court, which is called appeal against conviction. Like I said, different courts have their different laws as far as the appeal against conviction is concerned. In India, we have this under CRPC, Criminal Procedure Code. But please study petition carefully, like I gave you the example of VWAP. In financial contracting, there are various loopholes which are left by both the parties. I'm not talking about plaintiff, I'm talking about defendant also. The biggest thing we have as far as the injunctions in the financial contracts are concerned, whether this is ex-parte injunction or it is bi-parte injunction, is to catch this loophole. But for that, you need a very strong understanding, fundamental understanding of the markets, of that product, probably a financial institution or probably a process. Guys, like I said, please study the petition carefully. More importantly, the best remedy is on time to time basis, continue to search the new updates which are coming as far as the injunctions, the indictments are concerned. Like I said, the law is a very vast field. And in this vast field, you are supposed to be alert and active. That's more important. That is what I would like to convey. But having said that, the basic dispute starts from contracting. And the catches and misses are in petition. And unfortunately, the tendency is petition, no one study. But I do take petitions very seriously in my life. I study each and every word of the petition, try to connect that where is the hits, where is the miss, and then try to correlate my point with these hits and misses. This is what I would like to convey in this video. At the end, I would like to thank you, the Honorable Supreme Court of India, for making this point. And definitely, I would request Honorable Supreme Court to continue to guide us, and which definitely they are doing, and definitely they are updating us. Of course, the onus is always on us that we have to search the internet, we have to continue to download, print the various judgments, study it on a very in a very hardest way, try to link the things. Like I said, like financial market, law isn't easy. For many people, financial market is also easy. So similarly, for many people, law is also easy. But to me, law is really a very, very interesting subject. And if we able to link this with the financial market, then it make wonders. Because unfortunately, the fundamental understanding of financial market is very limited. Like if you open the Google and type liquidity swaps, example, you hardly get anything on liquidity swaps. Hardly get anything on the liquidity swaps. So suppose there is a dispute in any part of the globe as far as the liquidity swaps is concerned between any two counterparties, say Goldman Sachs, JP Morgan, or any two counterparties. Then the first thing which the court of law needs to understand is we are here talking about liquidity swaps. What is that? How it works, various permutations and combinations, on which product we can apply that, and so on and so forth. Henceforth, fundamental understanding is very important. Anyways, this is what I would like to present. Thank you very much to the Honorable Supreme Court for guiding us on time to time basis. This is Rahul Magan from Treasury Consulting Group. Renew my personal number +91 9899242978 +91 9899242978. Alternatively, you can visit our fixed income platform www.fixedincome.global. Guys, I'm reading this judgment in detail, which is Morgan Stanley Mutual Fund versus Karthik Das. There are a lot of other activities which are going in parallel, but I'm sure that once I'm done with the reading of this judgment, I would definitely have a very, very solid understanding on what basis the Honorable Court laid down these guidelines is. That's why I always stress, that in law, always take the download, rather print out of the judgments, study it, and try to link this with the outcome. Of course, it's a hard task, but hard task is a hard task. It's not an excuse, right? You have to study the judgment and you have to reach to a conclusion. That's really a mandatory thing, and rather it's an interesting thing, and you will end up learning more. You feel like you did very credible job. This is Rahul Magan from Treasury Consulting Group. Have a great time.